Every single week, a bank teller somewhere in this country gives a customer a piece of advice that sounds helpful, costs nothing, and quietly destroys the estate plans of thousands of families a year. The advice sounds like this: just add your kids as direct beneficiaries on your accounts, and you will avoid probate. Simple, fast, free. The teller smiles, you sign the form, and you walk out of that bank believing you have done something smart for your family. You have not. In many cases, you have done the most dangerous thing you could have possibly done. What your bank teller did not tell you is this: if your child has a disability and receives government benefits, a direct inheritance could strip away their Medicaid and their monthly support check within 30 days of the money arriving. If your child has a spending problem, an addiction, or simply no financial discipline, that direct transfer gives them full, immediate, unrestricted access to every dollar you saved with no safeguard, no structure, and no way for you to protect them from themselves. And if your child is a minor, a direct transfer to their account is not even legally valid. A court will appoint a guardian to manage the money, the legal fees will eat a portion of it, and a judge you have never met will control your child's inheritance until they turn 18. At which point they receive the entire remaining balance in one lump sum all at once on their birthday. The bank does not tell you any of this because the bank is not your estate planner. The bank is a bank. My name is Marcus Webb, and today I'm going to show you exactly why the single most common piece of estate planning advice people receive at the bank is also the most dangerous, and what to do instead. The story of Sandra and Ashley. Sandra Kowalski spent 31 years as a hospital administrator in Cleveland, Ohio. She was organized, practical, and careful with money. When she retired at 64, she had a brokerage account worth $295,000, a small IRA, and a home she owned outright. She had 2 children, her son Derek, who was financially stable and lived in Phoenix, and her daughter Ashley, who was 39, single, and had been living with a serious autoimmune condition since her early 20s. Ashley received Supplemental Security Income SSI every month from the federal government. She was also enrolled in Medicaid, which covered the medications and specialist visits that kept her condition managed and her life livable. Without those benefits, Ashley could not work, could not pay for her treatment, and could not function independently. Those benefits were not a luxury, they were her life support. When Sandra went to her bank to update her accounts, the branch manager, a helpful, well-meaning woman, walked her through the TOD form, transfer on death. It was simple. Name a beneficiary, and when Sandra died, the money would transfer directly to that person without going through probate. Quick, clean, no lawyers needed. Sandra named Derek and Ashley equally, 50% each. Sandra passed away 2 years later. Derek received his $147,000 and invested it. Ashley received her $147,000, and within 30 days, she had a letter from the Social Security Administration informing her that her SSI payments were suspended because she now had assets exceeding the $2,000 resource limit for federal benefits. And within 60 days, she received notice that her Medicaid enrollment was being terminated for the same reason. Ashley had inherited money she had no way to use, not for what she actually needed. She could not get a job. She could not manage her own medical care. The money began flowing out almost immediately, entirely toward medical expenses the government had been covering the day before. Specialists, medications, lab work, everything she had always had covered all at once, now coming out of her account. Within 22 months, the $147,000 was gone. The medical bills were not. She had to reapply for benefits. The process took 8 months. During those 8 months, she went without several medications. Her condition worsened in ways it will not fully recover from. Sandra did not do this to her daughter on purpose. Sandra loved her daughter more than anything on earth. Sandra walked out of that bank believing she had done something smart. What Sandra needed was a special needs trust, a specific legal structure that holds assets for a disabled beneficiary without counting those assets against their government benefit eligibility. The money sits in the trust. The trustee, not Ashley, not the government, controls distributions, spending them on things that genuinely improve Ashley's quality of life beyond what the government provides. Vacations, electronics, education, better food, clothing, a car. Ashley keeps her Medicaid. She keeps her SSI. And Sandra's $295,000 does what Sandra intended. It makes her daughter's life better, not worse. All of that was available. None of it required anything complicated. It just required someone telling Sandra the truth before she signed the form. Why the bank gives this advice? Let me be fair to the bank for a moment. because the TOD and POD designation transfer on death for investment accounts, payable on death for bank accounts, is not always wrong. For a financially stable, able-bodied adult child with no creditor issues and no government benefits, a direct TOD designation is genuinely simple and often appropriate. It avoids probate. It is fast. It works. The problem is that bank tellers and even many financial advisors give this advice as a blanket recommendation without asking any of the questions that would reveal whether it is safe for your specific family. They do not ask whether your child is on SSI or Medicaid. They do not ask whether your child has a gambling problem. They do not ask whether your child is a minor. They do not ask whether your child is currently in bankruptcy proceedings or has outstanding judgments against them. They hand you a form and tell you it simplifies things, and it does simplify things right up until the moment it does not. The 5 situations where a direct TOD or POD beneficiary designation causes serious damage. The 5 dangerous scenarios. Scenario 1. The disabled child who receives government benefits. This is the Ashley situation. SSI has a $2,000 asset limit. Medicaid in most states has similar or related limits. The moment a disabled beneficiary receives a direct inheritance above those thresholds, the clock starts on benefit suspension. It does not matter that the money came from a loving parent. The government does not make exceptions for inheritance. The solution is a special needs trust, also called a supplemental needs trust, named as the beneficiary instead of the child directly. Scenario 2. The financially irresponsible child. Consider a parent who has a son with a history of poor financial decisions, gambling, addiction, and inability to hold money for more than a few months. A direct transfer of $200,000 to that child is not a gift. It is a loaded weapon handed to someone who is not equipped to hold it safely. The money will be gone, often within a year, and it will frequently fund the very behavior the parents spent a lifetime trying to help their child overcome. The solution here is a spendthrift trust, which controls the pace and purpose of distributions. The trustee can release money for rent, education, medical care, and withhold it for everything else. The child benefits, but the inheritance is protected from the child's own worst impulses. Scenario 3. The minor child. Many parents assume that naming a minor child as a direct beneficiary is a kindness. The money will be there for them when they need it. What actually happens is this. A minor cannot legally receive a large sum of money directly. If there is no trust in place, a court must appoint a guardian of the estate to manage the funds. The guardian may be someone you would not have chosen. The court process involves legal fees, and when the child turns 18, they receive the full remaining balance all at once with no restrictions. 18-year-olds receiving large lump sums is one of the most reliable ways to see an inheritance disappear before the age of 25. A minor's trust, sometimes called a custodial trust or a 2503C trust, solves this completely, and it gives you the ability to set a distribution age that is actually reasonable, like 25 or 30. Scenario 4. The child with creditor exposure. If your child is in the middle of a bankruptcy, has outstanding civil judgments, owes back taxes, or is going through a contentious divorce at the time they receive a direct inheritance, those funds are immediately reachable by creditors and courts. Your life's work can walk out of your family in a single legal proceeding that has nothing to do with what you intended. A properly structured trust with a spendthrift clause protects inherited assets from the beneficiary's creditors, exactly the protection a direct transfer strips away. Scenario 5. The child who is not emotionally ready. This one is harder to quantify, but it is real, and every estate planning attorney has seen it. A child who has never managed more than a few $1,000s at a time. A child who has grown up in a modest household, who has no investment experience, no relationship with financial advisors, no frame of reference for what $300,000 means or how quickly it disappears, receives a sudden large inheritance and is psychologically overwhelmed by it. Studies of sudden wealth consistently show that a significant percentage of people who receive a large, unexpected sum lose it within a few years, not through fraud or addiction, but through ordinary bad decisions made without adequate guidance. A trust with a staged distribution schedule, releasing funds in thirds over 10 years, for example, or tying distributions to specific milestones, protects a child from the very thing that was meant to help them. The solution: name a trust, not a person. The fix for all 5 of these scenarios is the same. Instead of naming your child directly as the TOD or POD beneficiary on your accounts, you name a trust as the beneficiary. The trust already exists in your estate plan. It contains the rules you set: who receives what, when, under what conditions, with what protections. When you die, the account transfers into the trust, not directly to the person, and the trustee manages the distributions according to your instructions. This is not complicated. It is not expensive. It does not require you to give up control of your money during your lifetime. You fund the trust at death, not before. You simply change the beneficiary line on the form from your child's name and social security number to your trust's name and tax identification number. That one change on one form is the difference between an inheritance that works and an inheritance that destroys. 5 mistakes parents make with beneficiary designations. Mistake number 1. Using a direct beneficiary on every account without reviewing each family member's specific situation. What works for one child may devastate another. Review each account and each child separately. Mistake number 2. Never updating the forms. Beneficiary designation forms do not update themselves when your family circumstances change. A child who was financially stable at 30 may have a disability diagnosis at 40. A child who was able-bodied when you signed the form may be on government benefits today. Review your beneficiary designations every 2 to 3 years and after any major family event. Mistake number 3. Naming a disabled child directly without a special needs trust in place. This is the most common and most damaging error in this entire category. If you have a child on SSI, Medicaid, or any means-tested government benefit, do not name them as a direct beneficiary on anything until you have spoken with an estate planning attorney who specializes in special needs planning. Mistake number 4, naming a minor child directly. If your beneficiary is under 18, you need a trust. Period. Mistake number 5, assuming your financial institution reviewed your plan. Your bank did not review your plan. Your brokerage did not review your plan. They processed a form. The responsibility for making sure that form is appropriate for your family belongs to you, your estate planning attorney, and no one else. Your 30-day action plan. In week 1, pull every beneficiary designation form on every account you own. Your bank accounts, your brokerage accounts, your retirement accounts, your life insurance policies. Write down who is named on each one. Do not assume you remember. The form is what matters, not what you remember signing. In week 2, run every named beneficiary through the 5-scenario filter you just learned. Is this person on government benefits? Are they a minor? Do they have creditor exposure? Do they have a history of financial difficulty? Do they have the experience and emotional maturity to receive a large lump sum? If the answer to any of those questions raises a concern, that form needs to change. In week 3, contact an estate planning attorney and ask specifically about whether your accounts should name a trust as beneficiary rather than individuals. If you already have a revocable living trust, this may simply mean updating the TOD and POD forms to name the trust. If you have a disabled child and no special needs trust, make this appointment urgent. In week 4, make the changes, update the forms, file them with the institutions, keep copies. This is not a set and forget document. Put a reminder on your calendar to review them again in 2 years. The bank teller who handed you that TOD form was not trying to hurt your family. They were doing their job. But their job is not estate planning. Your family deserves someone who is. If this episode helped you see something in your plan that needs to change, subscribe and share it with someone who needs to hear it today. I am Marcus Webb, and your family's financial future is worth one honest conversation.